All right, the Supreme Court has sided with the telecom companies on call drops issue. It has put aside TRAI's recommendation. In fact, the Supreme Court says that TRAI's recommendation making it mandatory for telecoms to compensate subscribers for call drops is arbitrary, unreasonable and non-transparent.
The Supreme Court has rendered a historic judgment today by striking down the regulation in terms of which telecom operators were going to be charged for call drops. They've struck down the regulation as being ultra-virus, unreasonable and manifestly arbitrary. That's the judgment of the court. And they have also said that the procedure followed was entirely non-transparent. And they have said that Parliament should in fact frame regulations or a law in terms of which even subordinate legislation should be subject to principles of transparency, as is reflected in several judgments of American courts, including the American Supreme Court. And they have taken a cue from the RTI Act. I just wish to say that governments and ministers should not be populist when making decisions on.
All right, the Supreme Court has sided with the telecom companies, saying that TRAI's reasoning is not valid as far as call drops is concerned. It's not transparent and it's arbitrary. The Supreme Court has struck down an order by the country's top telecom regulatory body mandating mobile service providers to compensate subscribers for call drops, calling it arbitrary, unreasonable and non-transparent. The top court's order came on a clutch of petitions by telecom operators challenging the sector regulator TRAI's last year's notification asking them to compensate the consumers for call drops. Rajan Matthews, President COAI, is now joining us on the phone line. Mr. Matthews, clearly a setback there for the consumers.
I don't know that it is a setback for the consumer. I think it is something that is really in the long term positive for the consumer, because the industry has said that this is not the way to be dealing with the problem. This is a distraction. It diverts the attention and the resources of the industry to address the real problems. The real problems are problems of spectrum, are problems of getting timely clearances from the government.
Okay.
The Honorable Minister of Communications and IT has observed this, has helped the industry move forward, clearing permissions from defense land, giving us permissions on government properties and government buildings. This is the way forward, not to continue to penalize the industry and take away resources instead of allowing us to invest in the problem.
Mr. Matthews, but you know, really the consumer doesn't really understand the nuances between the government and the telecom companies. It wants a smooth operation as far as, a conversation or a text messaging or any of the things that the operators allow consumers to use via mobile phones. And for them, it doesn't really matter what's happening in the background. For them, the issue of call drops is certainly very important.
We absolutely agree with that, and as a consumer and a user of the services, I completely empathize with the end user consumer, and that is the point we are making all along. We are one of the countries that has one of the most complex networks and size of networks. We have three technologies, 2G, 3G, 4G, all working simultaneously, and we are in the process of rolling out these networks. And the handoffs between these networks are a technological challenge. These are developing technologies, so we have to make sure that we are focusing on those issues, not on penalizing us, as opposed to allowing us to invest continuously in the investment, getting the spectrum necessary, trading, sharing, all the things which are necessary for making sure the consumer experience is good.
All right, Mr. Matthews, many thanks for joining us with your views on that top court's order.